Hello everybody and welcome back to the Law of Contracts. In this video what we're going to do is take an introduction to the concept of consideration, which is the next major element that is required for our understanding of creating contracts, the creation of contracts, the formal different things that are necessary for a contract to exist. So, like I said, we're taking an introduction to the subject of consideration. This is actually the final part of our series of lessons on the subject of the creation of a contract. So, we've done a number of lessons on the idea of agreement. We've delineated that between the offer and the acceptance. We then spent a couple of lessons looking at arguably the least important, or one of the least important, or at least the least heavily litigated areas, which is, of course, an intention to create legal relations. And then finally, we're going to focus and spend quite a bit of time talking about consideration. This is the final element of a contract which is required to make it legally binding, for it to be a legally binding agreement. And so we'll take a brief introduction to the subject in this lesson and then start to dive into all of the very important factors and all of the very important considerations as time goes on in future lessons' time. So, as a basic introduction, consideration is required for the validity of a contract. And so if there is a contract without consideration, it will not be valid. It would be void or voidable. And as a result, or no, it would be void. It would have not existed in the first place. And as a result of which, we have to think about consideration in as much detail and with the same amount of veracity as we're talking about agreement and an intention to create legal relations. Simply put, consideration means that in order for a contract to be valid, there must be an exchange of items or commitments. There has to be a mutual exchange of items and commitments, i.e., you must be getting something in return for something else, or you must give in return of getting something. Whether that be items, like I said here, or commitments, whether it be if you're purchasing an item from a shop, you give money in return for said item. That is the consideration. Both people in the contract get something out of it, okay? Sometimes known as a quid pro quo, something for something else, okay? In English law, we do not recognize contracts which have one-sided commitments, which involve one-sided commitments. There is no recognition of a quote-unquote contract that has a one-sided commitment, where you just give something and you don't get anything in return, or you just receive something and don't have to give anything in return. These aren't contracts according to English law. An obligation can only be enforced if there is something which is going to be gained in return as consideration for the for the item or for the commitment that you are going to give yourself. That is what consideration fundamentally requires. The case of Curry and Misa from 1875 gives us a more formalist definition of consideration, the definition of which is only found in the case law, so this is just an example of a definition. The facts of this case are as follows. The defendant had purchased what are known as bills of exchange. These were essentially debt instruments in relation to corporate securities. There was an instruction to the defendant to make those payments to the bank of the claimant. This was because the merchant was indebted to them, and so they wanted the money to be transferred straight to them rather than having to go through the rigmarole of transferring it afterwards. When this debt was discovered by the defendant, it suggested to them that they were an unreliable trader, and so as a result of this newly found information, or this newly found implication, they instructed the bank not to acknowledge the check itself. The claimants would then seek to argue that a contract had actually existed between them and the defendant, the merchant and the defendant, should I say, and that this was, as a result of which, something that would have breached the contract in question. The claim was actually successful on the part of the claimant on the basis that there had existed a valid consideration in this particular contractual arrangement. Lord Justice Lush gives the following definition of consideration in this case. They say that, quote, a valuable consideration, in the sense of the law, may consist either of some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, or loss responsibility given, suffered, or undertaken by the other. This is the definition of consideration as per the case of Curry and Meiser, as cited in Finch and Fafinsky from 2017. A similar definition can be found in the 1915 case of Dunlop and Selfridge, where they say that, quote, an act of forbearance or the promise thereof is the price for which the promise of the other is brought, and the promise thus given for value is enforceable. These are two definitions of consideration. Simply put, it is something for something else. There is an obligation on the part of you to actually provide something to the other party in order to receive valid consideration, in order to receive whatever that other party is going to bring to you in the contract.